Okay, so we will get started with the webinar. Thank you so much for joining us, everyone. My name is Jie Huang. I am a senior associate at Scott Legal PC. And today we're going to spend some time to discuss the E-2 visa requirements and considerations for the renewal of the E-2 visa also. So just a few things before we get started. Some of you may know that the firm Scott Legal was actually founded on an E-2 visa 10 years ago. So the founder of the firm, Ian Scott, applied for an E-2 visa to come to the United States to establish Scott Legal. So the firm has successfully renewed its E-2 visa as well. So this definitely gives us very deep familiarity and expertise with all things E-2 visas. And Scott Legal is actually a full service immigration law firm. So we can handle any type of visa category, but we do focus primarily on E-2 visas. We have processed hundreds and hundreds of E-2 visas, and we do process many E-2 visa types that are considered higher risk, which means with relatively lower investment amounts. We have processed at consulates around the world, but our primary two consulates are Toronto and London. And we are continuing this webinar series, and we're doing at least two webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. We will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide, sort of an ebook, a booklet that regarding the E2 visa that you can use as a resource. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube. And we do encourage you to subscribe and hit the notification button for our YouTube channel, as we do regularly upload a variety of immigration law related videos that can be a helpful resource to you. Finally, we will send you a link that you can follow to set up a consultation should you wish to discuss your case in further detail with any of our attorneys. So I will lead the presentation today. I am a senior associate of Scott Legal, and I do have a wide variety of expertise on processing E-2 visas, and I'll be happy to answer any questions you may have. If you think of a question, please feel free to add them to the chat box or use the Q&A function to ask the question, and I will try and get to all questions. So without further delay, let us get started. All right, so what is an E-2 visa? So, as many of you may already know, the E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they invested in. Okay, so a non-immigrant visa, when I say non-immigrant visa, it means it's not a green card. However, it is worth noting that the E-2 visa holder can continue extending the visa indefinitely as long as the applicant continues to meet the E-2 requirements. And there are two options of how you can do this investment in a US enterprise. You can either purchase an existing business or you can start up a new enterprise in the United States. So those are the two options. Now let's talk a little bit about the eligibility requirements that you must prove in order to qualify for the E-2 visa. So the first requirement is that you must be a national of a treaty country. Now, there are over 80 different countries that participate in the E-2 visa program. And this E-2 visa is an option available to nationals of countries that have actually signed an economic treaty with the United States. And this does include many different countries around the world in all continents. And you can easily search for the list of treaty countries by Googling Treaty Country Department of State, and you'll be able to see the list. For example, just for a few examples, Canada, Mexico, the UK, New Zealand, Singapore, Jamaica, Philippines, etc., and South Korea, for example, are countries that participate in the E-2 visa program. Now, the E-2 visa is not available to nationals of certain countries that have not signed such a treaty with the United States, so it is definitely worth checking before if you're interested in applying for an E-2 visa. And several well-known examples of countries that do not participate include India, China, and Russia. However, let's consider the scenario if you're a dual national of a non-treaty country and a treaty country. You can still use the treaty country's passport. If you have a dual nationality to qualify for the E-2 visa. So definitely that is a good thing. And it is also worth noting that when we talk about nationality in the E-2 visa context, it means having a passport, practically, of that treaty country. And treaty country nationality does not depend on the country of birth. And that is something, a distinction that may be important to some applicants, because in the immigrant visa or green card context, the country of chargeability is the country of birth. But in the E-2 visa context, when we speak of nationality, we speak of, the country where you are currently a citizen and have a passport in. So, for example, if you're born in a non-treaty country, but afterwards acquired treaty country nationality, you can definitely qualify for the E-2 visa based on your treaty country passport. All right. So that was nationality. The other requirement is that you must own at least 50% of the E-2 company. And when I speak of E-2 company, that is the US enterprise that is either being set up or, being purchased. So at least 50%, 50% or more, so includes 50% ownership. And this goes to the requirement that the treaty country nationals must develop and direct the enterprise. Now, the other requirement that you must keep note of is that there must be a substantial investment. And this means putting money at risk. Okay, so what does it mean to put money at risk? And there is we do encounter this question many times where a client may ask, okay, I have, $150,000 sitting in my personal bank account. What if I just, set up an LLC in the United States and set up a bank account for this LLC in the United States? And what if I just transfer all of that money to the LLC's business bank account? Is that enough to be considered as investment? I invested $150,000 by transferring this money. And interestingly, the answer is no, right? Because the government is going to look at it and say, okay, you transferred all of this money to an LLC bank account for an LLC that you own 100%. But this money can be taken out at any time, right? And where is the proof that any of this money is at risk? So when you are creating a startup and trying to apply for an E-2 visa, when we speak of investment, we speak of money actually having been spent on tangible things towards actually setting up the business. So for example, you sign up for a commercial lease and pay the deposit for the lease, for example. Spend money on marketing and setting up a website for the business, or you spend money on legal fees on, the business structure, or, even legal fees if you're getting, some immigration advice related to the E-2 visa, setting up this business. So a variety of things that you would actually do to, spend on concrete things that work towards setting up your business. Those concrete expenditures would show that you've actually spent money, executed these capitals to set up this business in a concrete way. And that really shows your commitment to the business enterprise. So that is why the government looks at such spendings as investment placed at risk. Um, let's say if you're purchasing a business, okay? So putting funds at risk when you're purchasing a business either means that you have already purchased the business such that all of the purchase funds have already been transferred to the seller, or the one arrangement that you could benefit from if you want to hedge the risk of potentially the E-2 visa being denied and then you losing the money is that some buyers choose to use an escrow arrangement with the seller, okay? And As long as, so when we speak of an escrow account, to back up a little bit, that means you and the seller would agree to put the purchase funds into a third-party escrow account and have a specific condition for the release of the funds. And for the purpose of meeting the at-risk requirement for E2 investment, the requirement is that the sole condition of the release of the funds to the seller must be the approval of the E2 visa. So if there are any other conditions, that, could allow the buyer to walk away, for example, that would not count in the government's eyes to, as capital really placed at risk, right? So that is why when we work with, the business purchase situation, we review the, escrow arrangement, the escrow papers in detail to see indeed if the terms specify that the sole condition for the release of the funds is the approval of the E2 visa. But that is definitely one option you can, use if you want to hedge the risk a little bit. But generally, when we speak of investment, it is capital being placed at risk. It is very important to note that. Okay, so how much investment is enough? Now, we are going to look at a little bit more on the following slides, but the requirement is that the investment must be substantial. And really, there is no hard and fast minimum that is required under the regulation of the law. There is no specific dollar amount that is listed anywhere on what counts as substantial, but we do have sort of rules of thumb, based on experience. And an easy way to think about what is a substantial investment is that have you made all of the expenditures necessary for a business to actually be operational? So let's say if you are setting up a, health gym, for example, you would need to buy all the equipment or buy or rent all of the equipment that, you will offer to the clients. You will need to have, a point of sale machine. You will need to have furniture for, clients to come in. You will definitely need to have purchased, well, a lease. You have to have executed a lease for the, gym to operate. So those kinds of expenditures would definitely be necessary before a gym can open its doors. You may also may have needed to invest in advertising, such that and invest in signage or things like that, so that people know where your business is located, so that you will start taking clients after you open its doors. So really, what the government will be looking for is proof that you have spent everything that is necessary in order to get that type of business up and running. If it seems like a significant part of that is lacking, then that may not be seen as a substantial investment. With regards to when you're purchasing a business, if you are purchasing a business from the open market, then whichever purchase price that you paid to the seller to purchase the business would likely be counted as substantial, because that's the fair market value of the business in the open market. Now, let's say you're buying a business from someone you know, or, a family member, for example. That would be very risky, because maybe it would be difficult to convince the consular officer that the price that you paid for the business, for purchasing the business, was a fair market price. So in that case, in order to, substantiate that this investment was actually substantial by, being, equivalent to the fair market value of purchasing that type of business, you can maybe get a letter from an independent CPA, for example, analyzing the value of the business assets or the business that you purchased and confirming that it is indeed a fair market price. So there are different strategies you can use. But when we speak of some substantiality, we're speaking of an amount of money that is enough to have a particular business up and running, ready to open its doors. So everything necessary for that kind of business must have been secured through expenditures or otherwise. So when we speak of investment, the other thing to take note of is the source of funds. The government will want to know where you earn the money that you have invested, and they're really looking for sort of proof that it came from a legitimate source. Okay, so what kind of sources of funds can be acceptable for an E-2 visa? This can really be a diverse array of sources. It can be saved earnings from employment, your own employment that can work, or you can maybe have been gifted some funds from someone that you know, for example. And when you get a gift from someone that you know, for example, you would also want to go one step further and prove to the government where that person earned that money from. So getting a gift doesn't relieve you of the responsibility of proving the source of that funds that was gifted. A loan can also work. For example, a personal loan from a family member, for example, can work. We would present a copy of the loan agreement and also information about where this person earned the loaned funds, if it's a personal loan or if it's a bank loan, then it should be sufficient to provide the loan agreement with the bank that shows the terms and conditions of the loan. And what we're really looking for is the one condition that if you are using a loan for a source of funds, it must not be secured by either the E2 business or the assets of the E2 business. So it can be secured, the loan can be secured by unrelated property, for example, like your own house, or, a business that you have in the foreign country, for example, as long as it's not related to the E2 enterprise or the assets of the E2 enterprise. So it is important to provide the promissory note or loan agreement that can really clarify what the terms and conditions of the loan is. Um, Now, let's think about then some of the other requirements. So the business must be real and operating. What does it mean that the business is real and operating? Basically, it means that everything necessary for the business to open its doors must already have been secured. And we already went over this in the example of the gym. The equipment necessary should be there. Any furniture or point of sale machine, for example, that's needed, it must already have been secured. The business space, the lease for the business space must already have been secured. The business entity must already have been established. So either an LLC or a corporation, for example, you do need to have already a legal U.S. entity that could drive forward the business. All of those things must already have taken place. And if you can show that the business is already taking revenue in the United States, or if you already have employees, if you already went ahead and hired employees for the business, that can help meet this real and operating criterion. So hiring U.S. workers, that's one thing that is a very important element of E-2 visa eligibility. Um, the government is not looking for someone who will operate a one-person shop or kind of, a freelancer or something like that. The government is looking for businesses that will hire US workers to do the work. Okay. So your role really is expected to be someone to develop and direct the business, not necessarily, doing everything yourself and not hiring any US workers to, take care of the on the ground duties related to what the business offers. Okay. So, a record of hiring US workers, especially for renewals, if you already have an E2 visa and then, a couple of years pass, then you need a new E2 visa. It is very important to show your progress of hiring US workers. Our rule of thumb that we, recommend to clients is to have at least 3 to 4 full-time US employees by year 5 of operations. If you've only been operating your business for 1 or 2 years, I think it is understandable if you have a fewer number of employees. But definitely having no employees is very, very risky. We do emphasize the need to, show the government that this business is a business that will hire US employees. Finally, the last requirement that we'll go over is that the E2 visa is a non-immigrant visa, which means there must be a showing that the E2 visa holder has the intent to return to his or her home country if the E2 visa ends. However, for the E-2 visa context, it is usually sufficient to provide a signed declaration to that effect. It is considered, I would say, a relatively more lenient type of visa with regards to non-immigrant intent scrutiny than certain other types of visas. But definitely, if you have, specific facts that may signal immigrant intent, such as, for example, an immigrant petition that you filed, very recently, for example, those things could um, provide a little bit more risk, and definitely you should talk to a lawyer to figure out the strategy on how to respond to that risk. All right. So I think I already went over this very briefly on the previous slide, but there are two options for obtaining an E-2 visa. The first option is to start a new business in the United States, and the second option would be to purchase an existing business in the United States. And when we speak of escrow, in the context of purchasing a business to qualify for the E-2 visa, there is that option that investors could use to hedge against the risk that maybe the E-2 visa may be denied. To protect your investment, it is possible to use a third-party escrow account to where you could transfer the purchase funds, purchase price to the escrow, as long as we can prove that the sole condition for the release of the funds to the seller is the approval of the E-2 visa. There must not be any other conditions for the sale to go forward and to complete. Otherwise, the government may think that the funds have not been placed at risk. Now, the duration of an E-2 visa validity, let's talk a little bit about that. So how long will your E-2 visa be valid for? And this depends on your country of nationality. And you can easily look this up by Googling reciprocity schedule, Department of State. And actually, for many countries, the duration that you will get for the validity of the E-2 visa will be 5 years. However, depending on your country of nationality, it can be as short as 3 months. So definitely, it is worth it to check. The consular officer may make a decision to give you a shorter validity period if they have concerns about your business. So maybe they want, to see in 1 or 2 years to see if you really have, hired employees as part of, your business plan. Like, let's think of an example. If you're a national of the UK, and if you had a business in the UK, a consulting business, and you've ran it for, several years, but you actually have not hired any employees. And then now you're saying, okay, I'm going to open a similar consulting business in the United States. And then you go to the interview, and the officer is being like, okay, you say that you're going to operate a business in the United States, but you have a record of not having any employees in your UK entity. Maybe I want to see you again in 1 or 2 years to see if you really actually did hire employees in your E2 enterprise. So then, instead of giving 5 years, the officer may choose to give 2 years, for example. So definitely that can be one consideration that can, change the validity period of the E-2 visa. The other thing to note is that the validity of the E-2 visa itself is different from how much time you will be given when you're entering the United States on the E-2 visa. So it is a nuanced distinction, but it is useful to think of it as the visa stamp is kind of a ticket to the United States, right? So you need a visa to gain entry to the United States, and the validity of the visa is the time period upon which you can present this document to enter the United States. Now, you will present that, think of it as a ticket to enter, but when you're entering the United States, you're actually given 2 years for each entry to stay in the United States and develop and direct your business. So let's take the example of an E-2 visa that is only valid for 3 months. Now, within the 3 months validity, you present this visa and then you will be able to enter the United States on the E-2 status. But when you're being admitted to the United States on E-2 status, the CBP officer will give you 2 years that is the period where you're allowed to stay in the United States and continue to develop your business up till the I-94 expiry date. So the I-94 is what governs the period of your stay in the United States once you're admitted on E-2 status. So even if your visa itself is only valid for 3 months, you present that during the validity time, and then once you gain entry into the United States, you will be given 2 years to develop your business. So definitely important point to, you know, consider the distinction between the visa validity and, the authorized period of stay that you will get once you're granted entry into the United States on E-2 status. All right. So now let's talk a little bit about substantiality. How much investment is enough? So there is no hard and fast minimum dollar amount that is required in the regulations of the law, but you must invest a substantial amount of money, and the officer must find that it is indeed substantial. So there is a little bit of subjectivity there involved. What amount of investment will be substantial will depend on the type of business. It will also depend on where you apply in the world. So certain consulates around the world have a sort of a different threshold that they use when they're thinking of what dollar amount of investment is substantial. And also maybe depending on, the specific examiner that is looking at your case. It also depends on the overall strength of your case. For example, we've talked about the real and operating requirement and the marginality requirement, which is the requirement to have um, multiple US employees. Um, and if your business is strong in those aspects, for example, if your business is already taking revenues, if your business already has a roster of clients, and if your business already has employees, very strong on the marginality and real and operating fronts, then maybe you can convince the officer that even if the dollar amount of your initial investment was on the lower side, maybe you can convince the officer that it was in fact enough to get the business, up and running. Thus, they must find that it has been substantial. So really, a variety of elements can come into play when we, uh, assess the risk of, how much investment is enough to be considered as substantial. And when I speak of the type of business, it is very important to consider that because the expected amount of investment will differ based on whether it is a office-based, service-based consulting type business that, that is dependent on, human resources mostly and not really dependent on expensive machinery or things like that, or as opposed to a business such as, a restaurant or a retail manufacturing business where typically a higher startup capital investment is typically required because of the nature of the equipment that's required, the setup that needs to happen, or the amount of space or inventory that you would need to get that type of business up and running. And it is also important to note that the government does use what is called a proportionality test to determine substantiality of an investment. What that means is that the higher the cost that is needed for that type of business to become operational, the lower portion of the investment that the government will be okay with. And that really means that if it's a $10 million business that you're trying to set up, and if you've only, put in, a couple $1 million into the business, that will still be seen as substantial, even if you haven't, invested 100% of what's necessary, just because, the amount of capital required is so high that proportionally, you'll be able to get away with a lower proportion being invested in the beginning, as opposed to a smaller business, let's say, a business that is valued at, I don't know, $300,000 or $400,000 kind of business. In that kind of smaller business space, you will be expected to have spent 100% of what's necessary to get that type of business up and running. So that's what we mean when we speak of a proportionality test. It is sort of an inverse proportional graph where the lower the cost to set up that kind of business, the higher proportion the government will expect the money would have been spent in advance to, qualify for the E-2 visa based on that business. Now, I already spoke briefly on this in the first slide, but when you are buying a business as opposed to setting up a new business, the substantiality inquiry is a little different. So here, the officer will just compare the purchase price to the fair market value of the business that you purchased. So if you located the business in the open market, there was no, like it wasn't a closed transaction through acquaintances or something, but it was more of an open market purchase, then it is likely that the government will accept that because if you, purchase it at the open market, that is the fair market value. Now, if you have purchased the business through a closed universe, such as an acquaintance or, friend or a family member, for example, that's a little bit riskier. You may want to get independent confirmation that the purchase price does represent the fair market value of the business. Maybe an independent CPA can provide a letter analyzing the value of the business to help with that. So those are some strategies you can think about. Franchises. Franchises can be a good option for E-2 visas. Franchises can help because usually franchises have uh, set up systems for marketing and some goodwill even, and they provide assistance when you're starting up a business, kind of a startup package that has assets that you can use, things like that. So that may help towards real and operating and even marginality if you can show that this franchise, has the potential to be successful. And another thing to think about is any money that you pay towards the franchise to license the franchise rights, for example, to purchase the franchise territory, you can include in the investment amount that you're presenting to the consulate when you're setting up the business, right? So if you spent a lot of money towards the franchise, that can boost your investment amount if you're, otherwise struggling to find, you know, uh, sources for uh, sources towards where you can place your capital. Common good and bad E-2 visa expenditures. Not all expenses that you incur when you're preparing to start up a business will be considered a good E-2 visa investment item when you're presenting to the consulate. Because, there are some things that, that you incur in the process of preparing for this business, such as, you know, plane tickets to come to the United States to see properties, for example, or, meet clients. Maybe, you want to charge, um, costs of meals or taxi and transportation, things like that. Now those kinds of expenses we would typically not include when we're calculating the E-2 investment amount. uh, other examples that is more appropriate to include in the to investment amount include things like, securing a business lease and when you're paying rent towards, the business premises, or if you're purchasing equipment for the business, if you're purchasing computer equipment for the business that, you would actually use or your employees will actually use. Those kinds of expenses are more considered as typical investment elements that are related to setting up the foundation for the business. So those are the kinds of good expenditures we would include. Also things like licensing fees, if your business requires such licensing, legal fees, negotiating certain contractual items in a lease, for example. If you hire lawyers to do that, you can include legal fees. If you hire accountants to set up the payroll system, for example, if you pay a service to do that, that can also be included as a typical E-2 visa um, expenditure item that is definitely related to setting up the foundation of the business. So definitely, yeah, reach out to us if you'd like more guidance on this point. But not all things that you spend money on will count as um, appropriate expenditures to be included as part of the investment. All right, let's shift gears to another question that we get very often, which is, do I have to hire US employees? And the answer is yes. The E2 business must have present or future capacity to generate enough income to provide more than a minimal living for the investor and their family. And let's unwrap the present or future capacity aspect, right? So when you're initially applying for a first-time E2 visa, then, maybe you don't have employees yet, right? So then what you need to do is to convince the consular officer that your E2 business will have the future capacity to generate enough income to provide more than a minimal living, in which means, being able to hire US employees. And how do you prove that the business will have that future capacity? That is why a very well prepared business plan can be helpful, right? You can have a 5-year plan of how you plan to set up and expand the business, increase the revenues of the business to eventually reach that point, even if your business does not presently have employees. So definitely keep note that you will need to prove either the present or future capacity to have US employees. Um, so the recommendation is that demonstrating that you will hire employees in the next 5 years, the government may not require you to, hire multiple people in the first year. Maybe you do need that runway to develop the business, but definitely within the next 5 years, ideally you would be able to convince the government that you will be hiring 3 to 4, 3 to 5 full-time employees. Now, let's talk a little bit about the distinction between W-2 employees versus 1099 workers. And when we speak of W-2 employees, those employees are regular employees who are on payroll. And you would typically, deduct taxes and Social Security and things like that from the payroll, and you would, pay taxes on, those things. So those are the W-2 employees who are regularly providing services to, your E2 enterprise. 1099s are contractors, right? And so when we speak of W-2 employees versus 1099 contractors, W-2 employees are definitely favored. And it is our recommendation to, when we speak of hiring 3 to 5 employees, to make them W-2 employees, regular employees. Um, Aside of contractors. And the reason why we say that is because that will be something that the government will ask when you come in to, renew your E2 visa, for example. Maybe one of the first things that the officer may ask you is, okay, how is your business doing? Do you have any employees? Right? And when they speak of employees, they do mean W2 employees. Now, there are certain industries where using 1099 workers is a lot more common, right? So let's think of, maybe the food industry where you may have many servers that come in and they're paid as 1099 workers. Or let's think of maybe a construction industry where many of the projects are, driven with contractors. Maybe it's the industry standard to have many different contractors working on a particular project rather than having regular W-2 employees. In such a case, we would still recommend the business to have at least a few W-2 employees, but I do think that the case can be strengthened. You can still bring, proof that you've generated significant payroll for 1099 workers, especially if it is the industry standard to do so. So definitely, this question is nuanced, and we want to take into consideration your industry practice when we're discussing distinction of these workers. So I did mention this a little bit uh, earlier, but when you are applying for a new E-2 visa with a new business, the business plan will be an important aspect of how to prove that your business will have the future capacity to hire U.S. workers. Letters of intent or client contracts can also be very helpful because those types of third party expressions of interest can show that there is actual demand for your E-2 enterprise services in the United States. So it will be good to combine those two things. If you are applying for an E-2 renewal, or if you are applying based on an existing business in the United States, the important pieces of evidence include the Form W-2s. You ideally want to, show that there is already a record of having paid wages to multiple employees. Pay stubs for employees can also be helpful if you don't have W-2s or if the business is relatively new, so you don't have, those forms yet. Tax returns is also very important if you are applying with an existing business or if you're applying for a renewal. You definitely want to present the most recent tax returns and a couple of years extending back if the business had been operating for several years to show that there is significant revenue generation and that the business has been generally profitable in the past few years. And the revenue amount that is written in those tax returns will be important because you want to show that the business has been non-marginal. The revenues that the business would show on the tax returns should ideally be much higher than, what an ordinary person would make. Because the regulations require that the business must have capacity to generate enough income to provide more than a minimal living for an investor and their family. So tax returns will be very important. If the business hasn't been doing so well, then maybe it is also a good idea to enclose a business plan, showing and convincing the officer how you're going to make changes to really make an upward trajectory in the future to meet the marginality requirement. So, when you are presenting a business plan, what should it contain? The recommendation is the business plan contain an executive summary, because sometimes the officer, would maybe not want to read, all 20 pages of a business plan. The executive summary should provide a very concise presentation of who you are, what you do, and who do you sell those services to. Uh, the business plan can also contain some market analysis and research, providing, content and context why the business's offering is attractive in that particular region, in that particular industry. What is the market need that you are filling? A marketing plan can also be very helpful. It can show the government that you actually have a plan to expand clientele and really reach that upward trajectory if you're trying to prove that. Personnel plan is also very important. How many employees are you planning to hire and when are you planning to hire those employees and what roles would these employees fulfill? So that kind of information can be presented in a systemic basis in the personnel plan section. Finally, we highly recommend the business plan to contain a comprehensive and well-researched financial plan. We recommend having 5 years of financial projections, which can include a projected profit and loss statement, which shows how much income you are expecting the business to generate. And those expectations should really be based on intelligent calculations, right? How much volume do you, expect your services or products to, you know, be distributed to, and what is the pricing of those products and services, for example. So an educated calculation should, be based, should base these projections, income and expenses and profit. So those are the things that the government will look at. Balance sheet to show how the business will balance its assets going forward, and cash flow statement. All of those can be helpful to convince the government that your business will not be marginal in the next few years. All right, so then let's talk a little bit about some other considerations that may be relevant when you're thinking of applying for an E-2 visa. USCIS versus consulate. So by that, it is possible if you are in the United States on a different non-immigrant visa status, you can apply to change status to E2 status through directly applying to USCIS. So that's actually one option that you have. Now, one thing to note is that if you change status to E2 status from within the United States through USCIS, that change of status is only valid for that stay. So your present stay. So if you enter the United States on, a different status, let's say an F1 student, right? And then you have this business opportunity and you want to change status to an E2. Now, you can, if you meet all the requirements, you can apply to do that. And let's say you get that E2 status approved, and you can even, use premium processing to get an answer within 15 business days. So let's say you have the E2 status now. However, as soon as you will get the E2 approval for 2 years at a time if you apply with USCIS, but this as soon as you leave the United States to go to a different country, for example, right? That status, is gone. You will need a new visa to enter the United States on E2 again. And for that, you need to apply for an E2 visa stamp at a consulate. So so that is definitely something you want to keep in mind when you're thinking of changing status, is that the ability to travel internationally will depend on you having an actual E2 visa stamp, and the consulates abroad will not necessarily just approve the E2 visa application just because you had a USCIS approval. It is different from the context of other petition-based visas, that you should think of an E2 visa application at a foreign consulate as sort of a fresh new application, right? So the previous USCIS approval, will not necessarily mean that your E2 visa application at a consulate would be approved. Now, you can also apply directly at a US consulate to get the visa stamp. And if you do that, there are different considerations that come into play. Like, for example, uh, when you apply through USCIS, the USCIS is very lenient on how low the investment amount can be. So we've actually seen, USCIS applications approved with, 30K, 40K, a very low amount of total investment. But on the other hand, USCIS is very, very strict about the source and trail of funds. And it is quite extensive. If you are using your employment income to, serve as the source for your investment, for example, they will look to see proof of, your each of your paychecks hitting your bank account and being, accumulating in your bank account before that money is spent. And they're very strict, dollar to dollar accounting, matching for that source. So USCIS petitions may not work for everyone in all circumstances, for sure. But when you apply at a consulate, they are relatively more lenient on the source of funds aspect, but they may require a higher investment amount. Let's say you're applying at a consulate like, Tokyo, Japan, for example. They would, expect to see at least over $100,000 in, of investment, because they're used to seeing higher investment amounts. So definitely different strategic considerations when you're choosing the forum. And I did just go over the source and trail of funds aspect. USCIS can be very strict about accounting the source for every dollar, and proving that all of these monies have been maintained in a particular bank account, so that you can source it before being proven that it was spent on the things that you say that you spent on. Let's see. Loans secured by company assets. So yeah, definitely a risk factor there, right? Because one of the conditions of using a loan as a source of funds is that the loan must not be secured by the E2 business or the E2 business's assets. So definitely be careful of that. Gifts can be used, but definitely keep in mind that when you use gifts, you need to also show where the gifter earned that money from. So you need to go one step further and ask the person who gifted you the money to provide, documentation regarding the source of their funds. Maybe they sold a property. Maybe they, had their own employment income. If that's the case, then you want to get copies of their income tax returns, for example, to show that they did in fact earn that income. So you do need to go one step further to provide the source of funds. Because it's considerations for a small investment amount. Letters of intent can be helpful to support with marginality, right? Because that will show that there is actual substantial demand for your products or services in the United States. If you already have contracts with, potential clients through your company, that would definitely also be something to emphasize. You already have contracts, and you will, very soon start earning revenues. Those are things that can be helpful in persuading the USCIS officer that the investment was substantial, even if, it's relatively lower, because there is proof that the business will open its doors very, very soon after the E2 visa is approved. CPA letter can also be helpful. A certified public accountant can provide an analysis of uh, sort of the average volume of investment that is usually encountered in that particular type of business. And the CPA can confirm that such an investment would actually, in fact, be enough to get the business up to the point where it's ready to open its doors. So that can be a good supplementary form of evidence to mitigate the risks of a smaller investment amount. E2 visas for two investors, that is possible if 50 to 50, if there is a 50 to 50% arrangement, if you own 50% and if the other partner owns 50%, both investors can apply for an E2 visa based on that enterprise. One thing to note, though, is that each investor must meet all of the requirements, including the substantial investment amounts. So you can't have a situation where you only invest 20% and the other person invests 80%. So the money should generally be consistent with, the 50-50 split if you're using that kind of arrangement, because each investor's investment must be independently seen as substantial. So that's definitely something you want to take into consideration for a two investor type case. Substantive changes to the business after filing. That is a very important thing to note are if you were approved for an E2 business, but suddenly you want to completely change the business, that may not be okay. Certain expansions that are closely related to what you're doing could be okay as long as it's reasonably contemplated from the business plan. So let's say if you're an accounting firm and at one point you were focusing on this part of the population, but then you're expanding to that part of the population, like those kind of changes, would not likely be seen as a substantial change, like a fundamental shift. But if you start off as an accounting firm and then suddenly you acquire a restaurant, that kind of change will definitely be considered as a substantive change. So in order to do that, you need a new visa or another form of advance approval to do that. Otherwise, that can be seen as a violation of the E2 visa status. So definitely be careful of that and speak to your lawyer before you engage in such changes. Um, if you feel like your business wants to expand to a particular area and you know that in advance, then, when you're preparing the business plan or you're preparing the application, you can make sure to include those kinds of expansion aspects in your initial application. In that way, if you engage in these things in the future, that will not be a substantive change to what you presented initially at the consulate. Higher risk cases. There are some types of businesses that pose higher risk for E2 visa application. One of the examples is real estate type business. Um, Consulates are a little wary of things where if you're just buying a house and then trying to flip it and sell it and say that that is the E2 investment, that will not work because that really just seems like a passive investment, not really a real and operating business. However, if you're, doing a commercial real estate renovation company, for example, and if you have many, many different clients that you do that for, and it's not really just for yourself, then that can, that may, depending on the facts, that can qualify for an E2 visa if you can convince the government that that is a, commercial business operation, not necessarily your, individual, personal investment for capital gains, right? Similarly, equity trading has those kinds of risks. If you're just trading stock to produce profit for you and your family, for example, that may not be um, considered as a real and active operating business for E2 purposes. But if you're doing that for many different clients and if it's a really equity trading firm that you're setting up, then you may be able to use that to qualify for the E2 visa. Keep in mind the licensing requirements are quite strict in that area, so make sure that you have procured all necessary licenses before applying with something like that. Family business purchases are also risky. I did go over this multiple times in the previous slides. But yeah, the risk is that the government may think that really, it is not a fair transaction, and maybe substantiality may come into question. So generally, family business purchases, money changing hands between family. The government may also just think that there's really nothing going on. If it's just, they see the family as one unit. So definitely a risky fact pattern. CPA letter could help to overcome the substantiality front, but generally disfavored a disfavored category of um, case. Common reasons for E2 denials. Yeah, low investment amount can definitely be one reason. So substantiality, you must be able to show that you have spent everything that is necessary to get a particular type of business up and running. And a low dollar amount definitely could pose risks to that. The nature of the business, such as real estate or equity trading, as I mentioned in the earlier slide, that can prove challenging. Filing location and venue. So definitely you should work with a lawyer who knows the nuances between different consulates. Different consulates expect a different kind of, uh, you know, substantial investment, different dollar amount, for example. So if you're, applying with the too low amount at a particular consulate that expects a higher amount, that can pose challenges. Um, and also USCIS, right? USCIS is very strict with regards to the trail and source of funds documentation. So if you apply through USCIS and you don't have that sufficient evidence to the level that they require, then it can be denied. So definitely speak to an attorney to, figure out what the requirements are for that particular venue, that particular filing location. Client has business in home country that does not have employees. Yeah, if you have been operating a similar company in your home country and you have never hired anyone, definitely can be a risk factor. You'll need to, do some extra effort to convince the government why you'll do things differently in the United States and will actually hire employees, generate jobs in the United States. Issues with the adjudicating officer. Yeah, adjudicating officers are humans. Sometimes you may be unlucky and encounter an officer that is particularly biased against that particular type of business or, has a particular concern on your case. So that's always kind of a human element that can introduce a little bit of risk. And the other category of denials are cases that simply did not meet the requirements at the time of filing. And maybe it could have been the 50% ownership aspect. Maybe it could have been, not putting any money at risk. So we did encounter a case filed, through a different lawyer where the client had invested. So they had invested like 100K, put them in the bank account, but the money actually spent was only $2,000 of funds actually spent on concrete things, and the rest was just sitting in a bank account. And that is definitely not going to qualify as, substantial investment placed at risk, money placed at risk. So those types of cases, yeah, would definitely be denied. What does it take to renew an E-2 visa? And I will go through this quickly. Now, I know that we're running out of time. Um, Hiring U.S. workers is definitely key for a successful renewal of an E-2 visa. And the requirement is to hire 3 to 5 workers, W-2 employees, by the time you need to renew, you know, year 5 of operations. Provide updated financial data. It is very important to show all tax returns that the entity has filed up to date. We want to ask, is the company profitable, right? So profit and loss statements can be included. You really want to show, a positive upward trajectory. Um, there can be reasons for some fluctuations, and you can use, a business plan to explain the reasons behind such fluctuations and what measures you're taking to continue that upward trajectory. But yeah, general profitability is what the government is looking for. Payroll information for, current employees. You want to, show the government that you have employees, you have maintained employees, and they're still working for the business. Doesn't need to be the same people, but you do need to, you do want to show that, the business is still operating and has employees. If the company is not doing well, you should, yeah, be able to convince the government what you're going to do to get the business to a place where you will be hiring employees in the future. And finally, yeah, showing that the E-2 business continues to meet all of the E-2 requirements that we went over in the previous slides. So things that need attention are things like ownership changes, and changes to the type of business. You want to make sure that those changes were in line with what was originally presented in the initial E-2 application. Developments and adjudication trends, so we'll briefly go over those as well. So generally, E-2 visas are a category that has relatively high approval rates posted by the U.S. government, 80% to 90%. And this may also include, cases that are filed without a lawyer, right? So generally, this rate is a very good rate. Um, Investment purchases in the United States. So there is a difference, between buying stuff in your foreign country or buying stuff in the United States. And generally, what we recommend is to have the majority of what you will be purchasing to be in the United States from the United States. Um, that will probably work better for investment purposes. Government may want to see higher investment amounts, yeah, as time goes on, uh, what the government would expect as the minimum investment, to get a business up and running, would generally, tend to go up, with the changing, business conditions and changing economic trends, right? Hiring of U.S. citizens, buy American, hire American, was kind of a mantra in the, previous um, Trump administration. So that may impact adjudication of E-2 visas. More and more, the government officers would want to see that you're hiring U.S. citizens, hiring U.S. permanent residents as employees in your E-2 enterprise. Focus on employees rather than contractors. I spoke about this in the previous slides, but W-2 employees are a preferred type of employee to highlight, rather than 1099 contractors. Administrating processing is always a risk when you're applying for a visa through a consulate. And administrating processing can be triggered by different things. Maybe your name is, uh, produces a hit on the security screening or things like that. Really is a little bit unpredictable. But that can be, one risk factor that can elongate the waiting time until you receive your E2 visa. More USCIS filings. We have been seeing more USCIS filings, I would say, especially after the COVID pandemic, where a lot of the consulates worldwide had slowed down with the timing of how they process E2 visas. If you file with USCIS, there is the premium processing option. So if you're already in the United States in a different status and you want to change status to E2, you can pay extra for premium processing to the government, and they would provide an answer within 15 business days. Now, if they want to request more evidence from you, they will issue the RFE, and they would um, take another 15 days, 15 business days to adjudicate the case after you respond to the RFE. So that's definitely something you want to consider when you're thinking of the timelines. Longer waits at consulates. So yeah, after the COVID pandemic, there had been a global slowdown. I do think that most consulates have recovered since then, but definitely compared to USCIS, E2 processing at consulates around the world tend to be slower. So definitely expect several months before you can, get an interview for the E2 visa. All right, so let's see if there has been any questions. I think there's one question that came in. Okay, hi, I wanted to know, I have a YouTube channel and some online businesses. I used to invest and start the business for my E2 visa application. Can I keep the ownership of the YouTube channel, or can I just own but not manage any of the channels or business from the foreign country, I'm assuming? So I think this question is going to the issue of employment authorization once your E2 visa is approved. So definitely something to note is that once your E2 visa is approved, the work authorization that you get in the United States is limited to the E2 entity that you applied for the E2 visa with. So you're not really allowed to, side hustle to do other things or, provide services to other employers. I would say the exception is that if it is a business to business contract and it's something that if your business, if your E2 entity is sort of a service provider and then you're providing services to other companies on a business to business contract, you can be involved with things like that, but you cannot be directly employed by any other company than the E2 entity that you were approved for the E2 visa for. So that's definitely a very important distinction to make. So be very careful. Like you're not just allowed to come into the United States on an E2 visa and set up, completely unrelated entities and try to work for those other companies, right? You do need a separate E2 visa um, authorization for those types of new ventures. So yeah, definitely get in touch with us if you'd like to discuss the facts of your case in further detail. All right, so thanks everyone for your patience. We're a little bit over time, but we will close here. And yeah, please feel free to follow us for upcoming webinars in the future, and feel free to set up a consultation if you'd like to discuss the E2 visa with us in more detail. Thank you.